2008, I had an employee who went out on family medical leave, and when she came back, I had eliminated that position in our company entirely, and I had an offer for her to give her a part-time role. She took that part-time role and was an absolute disaster. After about 3 months, with great love and empathy, said, "Hey, this is not working out, but I want to help you find a role that's going to best fit your needs." 3 days later, I was served and sued for breaching the Family Medical Leave Act. And I spent the next 3 years navigating this process with her contingency attorney. The good news is that unbeknownst to me, I actually had employment practice liability insurance. I was assigned an attorney. They took it over. And after 3 years and after depositions, funny enough, this woman and I reconciled quite amicably, and I'm the one that ended up settling it. But it all worked out well. But thank God I had EPL. It was already stressful enough to build a business. But boy, I really didn't expect that coming out of nowhere. And that's why I'm so super motivated and excited, Michelle, to have you on today. And I'll let you introduce yourself, but not only do you run a really innovative law practice, you are touching on many of the things that we as business owners want to make sure we don't find ourselves absorbed in, because we need as much energy as possible to go and build the business that we set out to build when we had our great idea or our great vision. Now, for those of you that haven't been on these virtual office hours before, my name's Russell Benaroya. I'm a partner at Stride. And for those of you that don't know about Stride, we are a fully outsourced accounting, bookkeeping, and HR services department for high growth companies. We have about 100 clients, 20 employees, and we really pride ourselves around 3 fundamental facets. The first is team, the second is our approach to process, and the third is our curated technology to make sure that data is getting captured efficiently and reporting is done both efficiently and in an actionable way. So if we're really good at taking over the back office, that means you have more time to focus on the things that you do uniquely to build your business. And we also know that we have a responsibility to provide you with tools and opportunities and ideas and techniques and strategies to help you do that. I think today is one of those very important topics. So we only have 1 hour. Michelle is awesome. She put together some great material. And I have only one requirement for today, which is we have a good time, and this is really chill, and we interact, and we have a conversation, and you get some of your questions answered and get off this phone feeling like you had a really effective hour spent today. So with that, Michelle, I am going to hand it over to you. Welcome and thank you.
Sure. Thanks, Russell. I appreciate the opportunity to come and speak. You know, risk is one of those things that is in the back of our minds, but as the average business owner, we're running, full speed ahead, trying to build the business, trying to do the right thing, trying to take care of our employees and take care of our customers. And risk is sort of this, kind of itch in the back of our minds, but it's kind of difficult sometimes to put our finger on what it is or why we're maybe a little nervous.
Michelle, real quick. Stephen, could you put your computer on mute? I think I'm hearing you on your keys. Okay, awesome. Sorry, go ahead, Michelle.
Yeah, thanks. So my name is Michelle Bomberger. I'm the founder and CEO and managing attorney at Equinox Business Law Group. We work as outside general counsel for growing companies. And so by trying to create more of a partnership relationship, a more proactive relationship with businesses, we're able to look at how they perceive the risk of their business, how their teams are set up, how their processes are set up, and really dive into where it is that they can best grow. Every business has different moving parts. A lot of them are similar, but they're different in the way that the owner and the way that the industry requires that they move around. And our best work is going to be in really understanding that. As many of you probably know from working with attorneys in the past, it tends to be very transactional, and we're really trying to shift that relationship to be more strategic, because honestly, that's where we can do our best work. So the way we structure our relationships is on a 6-month fixed fee contract that is really an unlimited access to our team, both for you as the owner, as well as for your executive team and your managers. So they always have a resource to go to when a question arises. And so this topic is really near and dear to my heart because of the fact that there are these moving parts in the business, and there are different tools that are used at different stages in order to address risk. And every business has a different level of risk tolerance. And so these are things that move together and move independently to help protect your business in different scenarios. So we'll dive into some of the details and how you can use these as your business grows and changes.
Yeah. Oh, hey, Michelle, real quick, I'm just going to do a check. I just heard from Steve. He said he's showing as muted. Is there a second mic that he's unaware of? Let's see. I just want to make sure that you have a voice. I want to make sure that Steve has a voice. Let's see here. Hold on a second.
I just want to make sure I'm not disrupting you guys because
no, you're not disrupting. No, you're not disrupting. No, you're good.
No, you're good.
But you said I was typing in the mute and I was already on mute. That's why I'm confused.
You were already on mute. Okay, no, whoever I was calling out, obviously the wrong person, but we're good now. Sorry. No shame, no shaming here. Okay, I think we're good.
Thanks.
Yeah, sorry. Go ahead, Michelle.
No, you are good. So, we need to start out with our quick legal disclaimer. This is not an attorney-client relationship. This is general information for your purposes. If you have questions or you have something specific, you should talk with an attorney that knows more about you and your business before you take action. So just throw that out there. This is all very general. I'm happy to answer questions, but not specifically provide you with counsel as to how to proceed. All right, so what is our goal? And this is our goal as a business law firm as well, is looking at how the business can balance their business needs and their legal needs, the opportunities that show up every day and the risks associated with that, to make decisions that are smart and informed and move the business along that spectrum. There's always going to be risk in the business. There's really no way to avoid that. But understanding what your own risk tolerance is and how you want to approach that as a business strategy is really, really important. And it helps then to determine what this level of balance is for your business. We've had situations where we've provided counsel to someone and said, this is borderline, not legal. And that's, here's the consequences of taking this action. Here's the likelihood of you getting, quote, caught. And here's our recommendation. And ultimately, the business owner makes that call. It's their business, it's their risk. And we find, our position to be helping to understand where that spectrum is so that the decision is informed around the risk and the opportunity balancing that business owner has to make. So I want you just to take a moment to consider, what are the critical risks to your business? What are the things in the relationships that you have, in the events that could occur that really could shut down your business, that really could cause significant damage to your company? So just take a moment, we're not gonna spend a lot of time, but take a moment and think about what those things could be. Okay, so hopefully you have a short list, which probably isn't comprehensive because of the limited amount of time. But here's some things that came to mind for me right away. So contract disputes are pretty high on there. Natural disasters, what's the likelihood? But if it happens, it's big. Theft and fraud, that's coming up more and more often, especially with cyber issues. Employee claims, as Russell mentioned a little earlier. Unpaid bills or collections issues. Product liability, a lot of our folks are in service industries, but product liability is a huge one if you're in that space. Technology failure, what is your dependency on technology, and what are your risks associated with that not working properly? And then the loss of a key employee is another example. So these are ones that sort of just came off the top of my head. I'm sure you have others that come off the top of your head as you think about your own businesses. But keep these in mind as we go through the program and think about how these tools apply to different risk situations in your own business. Anyone, feel free to jump in with any questions or thoughts as we go through the program as well. So the three tools that we were planning to talk about today, I mean, obviously, one of the big ones is risk avoidance, right? Which risk avoidance only takes you so far. You're growing a business, you're going to have contracts, you're going to have employees, you're going to have things that come up in your business. And so, yes, risk avoidance is a piece for some people and not for others, funny enough. Some people are very risk loving, but these three tools are tools that are available, and they work both independently and together. And we'll talk a little about how they work independently and together. So written contracts, you probably are aware that a contract can be verbal. However, a verbal contract turns into a lot of he said, she said. So when there's a dispute, that verbal contract can only carry you so far. So written contracts are really key. Insurance policies, so understanding what insurance you should have. I really kind of liked Russell's comment that unbeknownst to me, I had EPLI.
Yeah.
Better if you know what you have versus not, but nice to have it if you didn't expect it in that case. Yeah. And having an entity with limitation on liability. And we'll talk a little about the differences between the types of entities that provide limitation on liability and how to make sure that you protect that, that right to liability protection as you take actions within the company. So I see these working sort of as concentric circles. The idea being that your contracts are intended to insulate the risks of a particular relationship. If you have the relationship with a vendor or with a customer or with a landlord or with an employee, the written contract provides the tools to set expectations and to resolve disputes. So a written contract then sets sort of the ground rules, and you hope that if that relationship goes sideways, that the terms of that contract will insulate that risk and insulate that cost and damage to the relationship itself. So there's a dispute, we've got tools to resolve it, we go through that process of resolving it, nobody's happy, but we can all walk away with what we agreed upon based on the terms of that contract alone. Sometimes the contract either isn't written or the contract doesn't apply. It doesn't cover the terms of what the dispute is. Or you have something come up that isn't a contractual issue. And that's when your insurance steps in. So you've got a dispute, it blows up outside of the contract, and your insurance then looks at it and says, oh, yep, we've got coverage there, EPLI or otherwise. And we will step in, take control of this matter, you pay your deductible, and we handle it going forward. So that is your second tier of defense. And then in a lot of cases, insurance doesn't cover it. Many of us have had experiences where the insurance company tries to find the ways not to pay and to find situations where they are not obligated under the terms of the insurance policy. And then, worst case scenario, the assets within the business are lost, you close the business, and you walk away. Your personal assets are protected by that entity that you have, and what you've lost is what you put into the business and what the business owns. So these three things, as you can see, you've got kind of bigger and bigger buckets of risk and where different players come in. And we've seen companies that set up and they're only an entity, they have no insurance and no written contracts because they're small, they're testing the waters, they're trying to see if this is going to work, and they're not going to invest in all these other aspects. We've seen companies that operate with insurance and no contracts, and so they can operate independently, but the real key is understanding what it is you're trying to protect and what are the right tools to put in place to manage that risk and protect your business.
Mm-hmm.
So we're going to start with written contracts. I think generally speaking, people know that this is important. However, it is uncomfortable for a lot of folks. It slows down the deal. It
Right.
creates a certain amount of tension in that conversation. It looks complicated. It sounds complicated because it's really easy to say, okay, I'm going to provide these accounting services for you and you're going to pay me this amount of money. That's easy. But then we get into these other areas of, well, what if? Well, what if? Well, what about the things that I'm creating, it's IP? Who owns that? And making sure that you think through that, because if your business really needs to own that IP, it's important that it's specifically stated in that contract. So some of the things to think about from a big picture standpoint on contracts is the contract needs to be specific to the business relationship. We've seen, a lot of situations where a contract has been pulled from one business area to be used in another, a master services agreement to be used in a contractor relationship, a residential landlord-tenant contract to be used in a commercial landlord-tenant relationship. So really thinking about and understanding what the purpose of that agreement is and whether it works for that business relationship. The core aspects, in my opinion, around the value of contracts is really setting expectations of the relationship and describing the rights and responsibilities of the parties. And that sounds easy, right? So, I'm going to do this and you're going to do this. But there's more nuance than that. So what about if you do something that I get sued for? Who's responsible for that? Do I have to pay for my attorney's fees or do you? I mean, you're the one who screwed up. Why am I responsible for that? And why do I have to pay for it? If we're silent on it, then there's no clarity and the default is going to be that everybody pays their own way. So thinking about it, and again, some relationships have significant amounts of risk of one party and the other party's actions creating liability for the opposite side, and some relationships don't. But thinking through this and understanding it and making sure that it's clear will really help you to sort through a dispute or sort through the process of your relationship. We've seen a lot of contracts also that are complex supplier relationships, and there's one paragraph on it. Well, what if you dispute the payment amount? What if you dispute the quality of the product? Do we have any audit rights? Do we have any ability to really sort of ratchet up the conversation? And do we have those protections? Because ultimately, if we have an audit right, or we have the ability to manage that dispute within the contract, it's less likely to blow up outside because we built tools into the relationship.
Michelle, can I ask you a couple quick questions?
Of course.
From a business owner standpoint. So one is, there's a story that I tell myself when I come into these arrangements, and it creates a lot of anxiety for me because I'm like, no, we just want to get this deal done, but then we're going to surface all of these issues and it's going to put the deal at risk. And so I like this anxiety spiral can happen. Mm-hmm. And I'd love to be able to come to the relationship and just feel a lot more comfortable that no, listen, it's all good. This is the most comfortable way to do it for you too. Really do this as a what's in it for you on the other side as much as it's what's in it for me. So part of it is state of mind I'm curious about. And then the second is, when do you get to that point of diminishing returns of over lawyering, right? I mean, lawyers can over lawyer, and sort of what's that point of equilibrium so you don't end up forgetting why you're even doing a deal in the first place.
Yeah, great questions. So I think the exercise of thinking through these points around what is the relationship, what are the risks of the relationship, and going into your initial discussions with the other party with these things in mind and talking through them. Because I think what happens is when the contract shows up and there's all of these aspects that have not been discussed at all,
totally
are in the paperwork, people then start freaking out. Well, what is this and why is this? And are you trying to screw me? And whatever those pieces are. And so if you've already talked about ownership of IP, you've already talked about, okay, well, I'm really you know, a little uncomfortable with the fact that you're going to have control over this part. So if you mess up, you'll pay me back. And if I mess up, I'll pay you back. Are we all okay with that? And you're having that in the business discussions.
Yeah.
And when it shows up in the contract, it's less of a surprise. And then you can kind of just work through, does it say what we agreed that it's supposed to say? And that's an easier conversation, I think.
Yeah.
With our clients, we work on a fixed fee model in part to help them understand what it is that's in the contract. Because that, to me, that's one of the essential aspects, is when you present a contract to somebody and you say, I don't know what that says, it's in there because my lawyer put it in there, that's not inspiring. And so if we build it in a way that you get the opportunity to ask as many questions as you can, we walk through it, we say, this is why this is here. Because most of the time it is there for both parties' mutual benefit. And if you can describe that to them, it's confidence inspiring and it moves things along pretty quickly. So I think understanding those risks, having the conversation early, and being able to walk through that contract with confidence will all move that along without creating this anxiety around the contract itself. On the over lawyering question, I think that also goes to the approach and the understanding of risk. I think, again, going back to relationships with lawyers, many businesses use lawyers to document transactions. And so the lawyer is going to look at it in a vacuum around risk. And they're going to say, this is risky to you, you shouldn't do it. This is risky to you, you shouldn't do it. Okay, we're entrepreneurs, right? Risk is okay. The question is it okay within the construct of what you want to accomplish here? You know, we've got a lot of situations where clients will say, you know, this is a contract with the company I've been trying to get for 10 years. I'm signing it no matter what it says. And that's okay, but it's actually important to know what it says, because you don't want to end up outside of the terms of that contract inadvertently. So for purposes of the over lawyering, it's really important that the lawyer is understanding what you're trying to accomplish and understanding your risk tolerance. So having that conversation on the front end of, I'm going to sign this anyway, just so you know, what I need for you to do is to tell me what risks there are, or what are the things that I should absolutely say no to because it's not a risk that I should accept, or it's outside the ordinary course of what you would expect in this relationship. So I think the blind reliance on the lawyer to review and comment is sometimes where that happens, and the lawyer is going to go to risk almost every time. And if you have a deeper relationship with that lawyer and they know you, they know how you think, they know how your business operates, they're going to know exactly the level of lawyering that is necessary and appropriate for that business.
Nitya, I see you used a previously never used feature on Zoom. You actually raised your digital hand. Okay, awesome. What do you got?
Quick question, Michelle. Is it possible, and how easy or difficult is it, you know, if I was to hire an employee before getting into the contract, to find out how many times they have sued or been sued, and similarly in getting to a contract with a company, perhaps, to get that information? Is that public? Is that hard to find?
Good question.
It's hard to find. It is public, but it's hard to find because the filings are public information, but they're typically in these state databases that you have to obtain access to. Sometimes Google searches will bring them up because they are, you know, public, but they aren't very easy to find. And I would be careful around searching for employee claims the same way that I'd be careful about even searching for employee information on the internet before hiring. We are, you know, highly litigious society, and the kinds of things that you may uncover around a protected class, maybe they've got a disability, maybe they're of a particular religion, maybe they're a particular sexual orientation, and the fact that you have gone out and discovered that and then chosen not to hire them creates a lot of risk there as well. Whether that was the reason or not, it's hard for you to defend that. And so just be careful on the employment side in doing digging in advance of hiring someone. So, but the information is out there if you dig deep enough.
Okay. Is it easy for a lawyer to find that information?
Depends on the state. We don't handle litigation in-house, and so I don't have access to those types of databases, but a litigator might be able to. I just don't know how comfortable they would be doing it. So,
Okay, thank you.
sure thing. So kind of moving on to some of the key areas of written contracts. Written and signed, this is actually really important. We are working right now with a client that was doing a business partnership with a company overseas, and they were very confident that this relationship was moving forward. They invested in equipment, they invested in signage, they invested in a lot of different aspects of the co-branding and that relationship. Invested in our time to build the documents out, and the assumption that they made was that all of that was going to be reimbursed or split somehow. And with the language barrier as well as the distance, it's now coming to light that they had no intention of reimbursing those costs, and nothing is in writing and nothing is signed. And therefore, they're trying to figure out, how do we resolve this, because we've now spent a couple $100,000 that we didn't intend to. So it's sometimes easy to get running on relationships prior to having everything signed, sealed, and delivered, but be a little bit careful about what you are committing to, the investments you're making, without clarity around the relationship and how it's moving forward. Even if they had just a email string that clarified this, that they could go back to, would be helpful. But they don't have anything in writing that suggests one way or the other. So goods and services offered, the more clarity you can provide, the better, especially around deliverables and timelines. We see this in software development contracts a lot. The idea that, oh, we're going to build, X product. Well, if for anyone who's been in software or IT, the difference between what the software developers think the product is and what the business people think the product is often vastly different. And so ensuring that you've got enough clarity to be able to go back and say, no, that is not considered an acceptable deliverable. And so just being really clear rather than generic. It's easier to be generic, but it's going to help you in the long run to put in the time and effort to specify what those deliverables are and the timelines are. The terms indemnification and limitation on liability are often confusing, especially since when you read those paragraphs, most of the time I need to parse them out. I pull out each of the phrases and make sure that I see how they tie in together. The idea of indemnification is that if I am sued or there's some claim against me because of something you did, you will reimburse me, and vice versa. And a lot of folks see that indemnification heading and they're like, oh, that's boilerplate, it's all the same. It's not all the same. It's really important that you pay attention to what it says, because if you are talking about a staffing contract where there's employees, there's liability around managing those employees and hiring and firing those employees, versus a software development contract where there might be copyright issues or there might be ownership issues, the indemnification needs there are very different. So it's important to look and see what they say and make sure that the kinds of things that you might have claims against you for are actually covered there. Oftentimes it's, if they breach the contract and there's a claim against you because of it, if their employee or agent performs, some sort of negligence or gross negligent act, and you have a claim against you because they're at your client site. So making sure that it's applicable to your business. Limitation on liability is actually sort of a cap. It says we are only limited to the amount that we've paid you. That's the max amount you can get from us. And these are not going to be 100% enforceable in all cases, but by having it in there, you at least create a meeting of the minds that was what our expectation was, and it's a starting point for the dispute and a starting point for the courts even. Ownership of work product. This is if someone is creating IP for you, they're creating a logo, they're creating an article, a video, do you own that or do they own that? And in order for you to own it, if someone else created it, it needs to be explicitly assigned to you. Otherwise, the person who created it owns it. And that's something that people don't really expect. They say, well, I paid for it. But if it's a creative work, the author of the creative work owns it by default, unless it is explicitly transferred. This is coming up a lot in consulting agreements as well, because as a consultant, you have tools that you have built for your business. You've got tools that you use over and over and over again with clients. And so depending on how the language of the IP is written and the transfer of the IP is written, you may be giving up the right to use the template, the baseline, because it's part of the deliverable to them. So you want to be really careful about how the IP is transferred if that's applicable to your business. Restrictive covenants, this would be non-competes, non-solicitations. They're not applicable in a lot of cases, but you may want a non-solicitation if you're working with someone closely that they can't solicit your customers or your employees. In employment relationships, people really want to put non-competes in. They are not enforceable at all in California, and in Washington they are, it's a very limited scope. So non-competes really need to be at the senior levels, so that you're protecting the trade secrets of the company. So there's really got to be a high standard for that. What are the termination provisions? So if we, is it sort of a standing contract that just terminates in 5 years? Or are there reasons why someone could terminate earlier than that? Dispute resolution procedures and location, is it mediation then arbitration? Or just does it go to litigation? And if you're working with clients or vendors who are in different places, where will that dispute be managed? We have a client right now, they're based in Montana and they're in an arbitration in St. Louis. It's awfully inconvenient. And you don't always get to control that, but it's important to know what it is. So I was going to just mention a good example of where a contract comes into play and is really important. We work with a number of staffing companies, and with staffing, the employee is the employee of the staffing company, a W-2 of the staffing company, and then they are placed on a temporary basis at the staffing company's clients. So that is considered joint employment in most cases, and that means that if something happens, that employee has a claim, both parties are responsible. The client is likely to go back to the staffing company and say, well, you're their employer of record, therefore it's your responsibility to deal with this. And we've seen situations where the client has made the decision not to fully report the wages due to that employee. The staffing company is relying on the information being provided by the client. And so when the employee says, hey, I'm owed this much money, the client says, well, staffing company, you're responsible for that. Staffing company says, well, you're the ones who didn't report it properly. And so that's a really great situation for the indemnity provisions and the limitations on liability provisions to be really clear, because legally speaking, they're both on the hook. So using the contract to separate that out is a really strong tool for them. So, all right, let's move on to insurance. I expect that most of you have some forms of insurance. And as I mentioned earlier, insurance steps in when the contract fails or there's no contract in place, or there's no contract that applies. So there may be an error by an employee. They've gone in, they accidentally trip and knock over the $10,000 vase, or some other damage that they do due to either negligence or just error. Oftentimes your general liability policy will cover something like that, or your client comes into your office and there's some damage to them. Another situation is where a contract dispute gets out of hand, there's litigation, and insurance may settle or defend if it's covered. So the EPLI example that Russell mentioned earlier is a good example of that. And then there's damage outside of your control, natural disaster, breakage, theft, something along those lines that, that is covered by your insurance policy. So those are examples. Some of the types of policies that you should think about, and again, they're very specific to your business. General liability should be held by everybody. It tends to be fairly inexpensive and very broad. Since Russell mentioned, not being aware of his EPLI, it might be that it was covered as a small aspect of general liability rather than a separate employment practices policy. But you should look at having a separate employment practices policy as well if you have employees. The amount of coverage for some of these ancillary areas is oftentimes very limited, and so you want to make sure you've got sufficient coverage based on your risk. So general liability covers the actions in the company. So the company goes to a client site, something bad happens. They are, usually there's a little bit of auto that's covered if the employee is in an accident while at work or while working. So it's all of your stuff that's covered and some of your actions that are covered. Professional liability applies more for licensed professionals, sometimes consultants. So usually if there's a claim, the employee, the company and the owners, or the person who actually provided the service will also be sued independently because their professional opinion was put on the line. And so with that, the professional liability applies. In a business that doesn't have licensed professionals, this is not as commonly needed. Errors and omissions applies to decisions that are made typically at the executive level, sometimes as a licensed professional as well. So covers directors and officers in many cases. And I would say this is most important if you have a lot of outside investors or outside board members who would be asking questions and bringing in an outside perspective on the operations. If it's a family business or a couple of partners where everybody's the same people, there's less of an issue of errors and omissions. Cyber is becoming a much bigger deal. You should really look into it. It's not terribly expensive, and small businesses are at a higher risk because their systems are typically not as secure, especially if you're keeping personally identifiable information or credit cards. It's important that you take a look at that. Business continuity, if your business has to shut down due to natural disaster, typically a natural disaster, but maybe it's a damage to the infrastructure, this pays for your business to stay open basically while it doesn't have money coming in. Employment practices covers you as an employer in your relationships with your employees. So employee has a claim against you, this is where that comes in. Key person life insurance, you as the owner should really look at that, especially if there's multiple owners or your family is somewhat dependent on the business. That way, if something happens to you and the business can't continue, there's at least a payout. Or if something happens to you and there's a buyout triggered in your ownership documents, that there's the money available to purchase that ownership back from you and your family gets that money. If it's a key person, an executive team member who's not an owner, it's still worth looking at as well if it's going to be difficult to replace that person. The key person policy can help you with the funds to find that person. Product liability, if you're putting any products on the marketplace, that's worth looking at. Auto, and then I mentioned captive briefly here. More and more companies are looking at self-insurance, and so captive policies are the company funds the insurance rather than buying insurance elsewhere. There's some tax benefits in doing that as well, or there can be. So that's something to look at if you've got a bunch of cash sitting around that you want to fund your own insurance policies. So that's a lot. I'm happy to talk a little bit more about those if anyone has questions.
And Michelle, I'm time checking. We have about 18 minutes, just so you know.
I'm following. I gotcha.
Yep. Okay.
So key considerations in insurance policies and coverage. I think the most important thing is what do you have and what do you need to protect? Honestly, taking a look at what are the things that can happen and how do you stay in business? So thinking about those pieces and the list of policies that I mentioned earlier, what is it that really applies to you in order to protect your business? Understanding what the notice requirements are for a claim. So if you find out about a claim and you sit around and you wait and wait and wait, sometimes that precludes you from filing and precludes you from getting their help. What are the policy limits that, you know, many of you probably have contracts that say you're required to carry insurance of, you know, used to be kind of $1 million per incident, 2 million combined. Now it's more like a 2.5. So what is it that is typically required by your customers, and balancing that against what you need, and is that negotiable? I have seen folks negotiate that from a 5.2 to a 1.2, just depending on the relationship, because the other side is going to ask you for the maximum they can get, but it may not make sense for the kind of work you're doing. This next point is the most difficult, because I don't know if any of you guys have actually read your insurance policies, but they are painful, very, very painful to read. And so trying to understand what is not covered, really leverage your broker and ask those questions. You can say, hey, here are the risks that I have in my business. Here's the stuff I want to make sure I protect against. Does this do that, and show me where? Because really, that is the benefit of having insurance. And if you don't know that the risks that your business has are actually covered, there may not be a purpose in having it for at least that particular piece of risk. Defense costs, inside or outside the limits. So the idea that, you've got a policy coverage of $1 million. Well, if it's going to cost $600,000 to defend it, it leaves a lot less to settle with. So understanding how those pieces play in. And then this is an area where businesses often really fall down, and that is revisiting the needs regularly. So what do you have and what do you need as your business changes? Employment practices is a really good example. So you have 1 employee, you have 2 employees. Okay, my risk is probably kind of low. And before you know it, you have 10. Okay, well, at what point does this make sense for me to invest in? So really kind of revisiting those needs. And same thing with, cyber. Most of us haven't really thought much about it in our businesses. But as these risks of, hacking and fraud increase, for the relatively small amount that it costs, it's worth looking into. Any quick questions on insurance? I think this is the one people are most familiar with.
Yeah.
All right. So entity. Certain entities provide protection from personal liability. LLCs and corporations do, partnerships and sole proprietorships do not. When you create an entity, what you are creating is a lot of people don't like the word person, but that's kind of the easiest way, I think, to look at it, a person separate from yourself. You happen to be the assigned or authorized individual to make decisions for that entity. And so you need to think about the entity making a decision rather than you making a decision. This is really, common when it's a single member LLC, and business owners often, especially when they're starting and when it's a single member, they don't really think about the business being separate from themselves. If it's not separate from you, it's a sole proprietorship, which does not provide liability protection. So once you set up the LLC, you want it to have certain formalities, and you've got to be somewhat disciplined around making sure that money is treated as money of the company. So if you need to pay your mortgage, the company writes you a check and then you pay the mortgage versus the company paying the mortgage. And yes, it sort of feels like it's all the same, but it's not, because you've set up this person that has its own bank account, its own credit card, its own decision making, and you just happen to be an agent for that person. So there was a question around LLCs, single member LLCs, and the liability protection that they provide. There's, a lot of folks who say, well, it really doesn't buy you much. The thing to remember is the structure of an LLC is a legal structure, and its intent is to provide liability protection to the owners. It's purpose. And so if you treat it like a separate person from yourself, it has its own insurance, it has its own contracts, you operate in the name of the company, then it will protect. It will do what it's supposed to do. But if you are not disciplined about that, it's very easy for someone to come in and what's called pierce the corporate veil. Between LLCs and corporations, LLCs are a lot more flexible, which is why they've become so popular. They aren't required to have a lot of these formalities, which is again where it's easy for people to fall into the pierce the corporate veil and lose their protection, because those formalities are not legally required, whereas a corporation they are. With a corporation, people fall into the problem of not actually doing the corporate formalities that are legally required. So just thinking of it as, once a year we sit down, we have a meeting, we make decisions, we make distributions. Just thinking about it as a separate person from yourself will get you pretty far on that. So as I mentioned early on in the program, if your contract doesn't protect or insulate the dispute and there's no insurance, then, worst case scenario, you say, all right, we'll just walk away from the business. We'll just close it down. All those creditors get whatever happens to be in the business, and you're going to feel really, really bad about that. But that's, an option that is available, and it's why these entities exist, is to protect the business owner and allow them to be creative and to grow businesses. If you had liability for everything your business did, you may not actually start the business in the first place. Mm-hmm. Remember that personal guarantees are personal obligations. So when your landlord requires that you sign personal guarantee on the lease, if the business can't pay, then you are personally obligated to pay, and there's no getting out of that. So just remember that anytime you put your personal name on the dotted line, that is a personal obligation. And so you should always be signing on behalf of the business unless you are intentionally guaranteeing, which is pretty common for, business loans, SBA loans specifically, and leases are pretty common areas where we see personal guarantees as basically a requirement for getting that deal.
It does create some misalignment of interest. I was in a business, we had investors, but I was personally guaranteed on some equipment. The business wasn't doing great. The investors wanted me to stay in and involved at all costs. And I'm looking here at this, I've got this pending personal guarantee that was going to impact me and my family, right? Mm-hmm. And so it created this really difficult misalignment that, it was just hard to navigate.
Yeah. And you see the same thing in a situation where you have multiple partners and one partner is financially more stable than another. Yeah. And so the personal guarantee is usually, everybody needs to sign it, but ultimately the one with the more money is going to get the hit. And so trying to figure out how to balance those things in a way that really makes sense, because your incentive to close that business is very different than theirs, because you've got a lot of personal obligations on the line.
Yeah.
So, and then owner agreements, shareholder agreements, operating agreements are really important to define how we manage the business, restrictions on transfer, and if we're going to shut down the business, how does that work and what does that look like? So if you've got an LLC or a corporation with multiple owners, just making sure that you've put that's a contract, but it's a contract relating to how do we run this business. And so it's one of the more essential ones to spend some time on and make sure that they work. All right, so just kind of looping back to this graphic, again, you look at the contracts, kind of then the insurance, and then the entity. And so hopefully there's a few insights around how these things play together with, what if I don't use a contract for this situation? What other tools do I have? What is the risk of this contract or this relationship compared to the other pieces of the business? What if I have a sole proprietorship? I mean, I don't see any business situation where you wouldn't set up an entity. It's easy, but if you're going to do it properly and maintain it, because it really does provide that insulation for your personal assets. So I had put in place just a quick scenario here, which will just kind of flow through pretty quickly, but hopefully it outlines a couple of these areas that we've talked about here. So there's a technology services firm. It's an LLC with 3 owners. It has 30 employees, or 30 people working for it, including 10 contractors. And the workers are often, on-site at client locations. So fairly straightforward, doesn't seem terribly complicated. So what happens next? So one of the contractors is in a car accident while driving their personal vehicle to a client. Neither the company's nor the employee's auto insurance policy covers the accident. Because one, they are a contractor, not an employee. And I put employee here, they weren't an employee, they were a contractor. But even if it was an employee, if it's being used for work, the employee's auto policy probably won't cover. Because this is a contractor, the company's policy probably wouldn't cover either because it was a personal vehicle. So understanding how people are using their tools within the business and making sure you've got coverage. So now you've got this contractor, they're injured, they go to the doctor says, were you at work? And they said, yes. Well, who was your employer? Oh, well, company was my employer. Well, company's not your employer because you're a contractor. However, now company is audited and all the contractors are deemed to be employees. Company owes $100,000 in back taxes and penalties. I want to highlight this just because there's a lot of use of contractors as extensions of your employee base. And so really make sure you understand the difference between a contractor and employee and set those up properly. We don't have the time to go into that, but if someone has questions about it, I'm happy to answer that separately. It is an area that it's pretty high risk right now because the revenue agencies know that it's an easy way to go in and get some quick money because a lot of people have misclassified employees as contractors. So then there's this client claim, employee uploaded some sort of virus into their system, and the employee says, well, they told me to do that. The insurance company says this is employee malfeasance, and therefore we're not covering it. The contract requires arbitration. It's silent as to where, but it's probably in Portland where the event actually took place. So the company falls behind on its rent, landlord evicts them, and the owners decide to dissolve the business because all of these things are just way too much. But they don't have a written agreement, and they don't know who gets what. I put this in, the IP's mine. And so then the landlord tries to pursue them for personal liability by piercing the corporate veil because they didn't have a lot of their documentation in place. This is what we call a kitchen sink scenario. So in law school, these are the kinds of things we would get for a question. What do you see? Hopefully not all these things happen to any of you.
Somebody should have even started the business in the first place. This is like the biggest disincentive to be an entrepreneur.
And this is why people don't call lawyers, right?
Right.
Let's go on to what are the things that they could have done differently, just quickly. Yeah. If people are driving for work, what auto policy covers? Are they driving company vehicles? Are they driving their own vehicles? The biggest thing here I wanted to mention is this contractor relationship. Remember that a contractor is someone who's running their own business, providing a service to your company. So they need to have a contract with your company. They need to be responsible for their own business expenses, their own insurance, and just really making sure that you're thinking about what is a contractor versus an employee in your business. A lot of times they're very mixed, and there's a lot of risk associated with that. Ensure your company decisions are formalized and finances are separate. We talked a bit about the corporate veil. In this case, we don't have enough information to know under what basis the landlord was going after them to pierce the corporate veil, but it's just something to highlight to make sure that you're thinking about the company as separate from yourself and documenting that. The operating agreement would help them to figure out dissolution. Let's say they were 20, 60 owners. Normally then the assets are going to be divided 20, 60, but maybe somebody contributed a piece of equipment or IP that is particularly valuable to them and they want it back. Well, what's the value of that? Is that worth 30% of the business? Is it worth 60% of the business? So really thinking through those things so that it's clean. Oftentimes when you get to a dissolution, people aren't happy. And so, thinking that we're all going to be able to just sort of split the pie and walk away is maybe a little bit naive. Craft an employee handbook and agreements to clearly delineate best practices. If you have policies, have a way of just reinforcing them and making sure that your employees know about them. Ensure you've got insurance to cover critical risks, and then contracts with customers that allocate risk. In this case, because we have a bit of a he said, she said, we don't know, whose fault it was that the virus was uploaded. But at least you've got clear dispute resolution procedures in order to work through that and hopefully clear allocation of risk. So like I said, kitchen sink is a little scary, but there are these tools, again, within the construct of the entity, the contracts and the insurance that they could use to think ahead and put these things in place. So as kind of a wrap up, how protected is your business? What are the biggest risks in your business? What are the events that could cripple your business? Really have these in mind. Once a year, maybe just sort of sit down and say, okay, what's changed? What do we have in place? What do we not have in place? Do we need to shift? What relationships are new? Do we have written contracts? Do we understand how we can get out of them if we need to? What insurance policies do you have, and do they really address the risks that your business faces? What type of entity is your business, and do you maintain the corporate formalities? And then consider taking a business health assessment. I mean, this is something that we provide to clients when they come in the door, which just asks about kind of 30 key, how comfortable do you feel about your business's position in, with respect to its insurance policies, with respect to its corporate formalities, with respect to its contracts, succession planning. So it's just a list of questions, and I'm happy to share that with anyone who wants to kind of do the quick checklist on it. But really just spending a little bit of time thinking about risk in your business and what are the tools that you have in place or could put in place to feel more comfortable with the fact that these risks are addressed, but then in practice, make it fairly easy to deal with them if they arise. Because ultimately, you're not in a place of comfort. You're in a place of sort of panic when some of these things come about. So that thinking process is a really critical part of the planning. So I know we don't have a lot of time for questions, but I'm happy to answer them either via email or via phone if anyone has questions that they have. And
awesome, Michelle. So everybody look at Michelle's email address. I really want to respect people's time. So if you have questions, please email her. I am equally inspired and motivated, Michelle, and then equally ready to go back to bed. Like, sort of, like, oh shoot, all of these issues that you brought up that are super relevant, but easily pushed aside as we're just trying to like build enterprise, right? We're trying to solve product market fit. We're trying to sell a customer. We're just trying to stay in the game. But these areas, I think are a good strategic advantage if we understand them and execute with some discipline. So really, really appreciate it. Thank you so much.
Of course. Thank you.
And everybody, thank you so much for your time today. I'm sorry we didn't have as much time after as I would like. That's why I want you to write down Michelle's email address and send her questions. Next virtual office hours, I think I am going to lead them, and I'm trying to figure out if I want to do it on how to lead the most effective team offsite, or how to build the most effective one-page strategic plan for your business. If you have a opinion one way or the other, email me and let me know. But that's going to happen in the next couple of weeks. As always, love this call. Really appreciate the support and the interest. And oh my God, the pun is going to kill me. But let's keep striding. Woo! All right, everybody. Have a great day. Thank you so much. And thanks again, Michelle, and everybody for attending.
Thanks.
Okay, take care. Bye, everybody.